Hello guys, we are Team 1 and we'll talk to you about common law. What is the common law? Usually referred as the laws of the land. The common law is essentially a body of legal rules and principles which are created, developed and applied by the judiciary. Judges sitting in court deciding disputes in individual cases either in civil or criminal jurisdiction. The common law has as its primary source the case law, which is a body of judicial decisions rendered by the higher courts previously.
The doctrine of precedent embodies a decision-making process according to which a judge, when deciding a case today, looks back at how judges decided a similar case in the past. What principles or reasoning did they apply, and the judgment to be rendered will necessarily follow those principles of reasoning into the instant case. Judicial decisions that have already been made in similar cases are documented in collection of case law, now as yearbooks or law reports.
William Blackstone, in his celebrated book Commentary of the Law of English, defines the common law as the one which was to be found in the record of our several codes of justice in book of records and the judicial decision, and in tracy of learning sake of the profession, trustee and the head down to us the from the time of antiquity. They are the laws which gave rise on only to the collection of maxi and the custom which is now called be the name of the common law. Platon's work is the tremendous import to the study of common laws. He was in the free author committee to make a systematic compilation of all different norms of the common law in English. We were still seen and probably the most progressive effort of the compilation in the English law history made in single author.
William the Conqueror invaded England from France. He was the first ever king to have the idea to try to produce an unified system of law around England and Wales. At the time of the invasion, there was a complex system of law and justice in the counties and shires. There was no unitary national legal system at that time. English law evolved from oral customary rules that vary from region to region.
William the Conqueror was interested in establishing his power and order in a relatively unruled kingdom. He laid the foundation of the legal system. He understood that in order to exercise real power on the citizens, he needed a central system of justice over which he as a king had power and he had laws that would be obeyed by the citizens. The cura reaches a court of law that comprised the king himself and some of his most entrusted advisors. It would be an advisory body for the king, but also it would be a place where people would bring their disputes to have them decided by the curia.
The courier regis will travel around, going around to different areas of the country, and people will come to the den and bring their grievance, complaints and accusations against other people, and the king and his advisor will give ruling of the dispute, judgment. This is one of the most important courts at the time, which was called the Court of King Bench. This activity marked the beginning of the common law system.
Henry II assumed power after a period of deep instability and considerable disruption. He wanted to reform land law and to deal with rampant crime. He played a significant role in the development of the legal system. For the first time, judges were sent out from London to dispense justice in other parts of the country.
There were only 18 hoods in the whole country. 5 of the 2 hoods were ordered to the Hague. Their permanent seat in London in the formed the Court of King Peace, which sat in the Westminster Hall. In 1666, he used the celebrated essay of Clarendon, a declaration in which determined that remaining hoods would be sent out to the travel to different parts of the country to dispense the hoods of Westminster. In this gradual way, local laws were replaced by new national laws that were come to all, the common law. Until decisions of these hoods were reviewed, and gradual decisions came to the record and the public, and the practice resulted in the decision which applied in the sector, forming past precedent applied in the late UCAB. Westminster Hall in the London and the Hoods traveling around the country led the gradual formation and the consolidation of the common law system. The first sample of law reports date back from the century in the early years of King Edward I to send to the under 72. And thus early law reports are the count of the yearbook. They were the principal source material for the development of concepts and the mentor. They were originally translated in the French of Latin.
The content of the law at that time was primarily oriented and largely at preventing bloodshed by recognizing the right to property, personal freedom, and punishing people who committed violent acts.
It is relevant to note that the eye system endured until 1971 in England, but some aspects of that original system still remain in England nowadays. Henry II reformed the original configuration of the jury system for dealing with criminal cases. Resort to violence was prohibited on the basis of the common law.
We appreciate the attention, and I hope you have learned about the common law.